I had an interesting question come up on a post that I had made on LinkedIn related to an easement on a small piece of property. And this particular easement, just where it was located and the type of easement it was going to have a significant impact on what you could actually build on this lot. It was a small lot to begin with, and then this easement probably removed about 25% of the buildable area of the lot, just the way the easement was configured. And so I had posted about that on LinkedIn, and I had another real estate professional ask a good question, and so I replied on LinkedIn, but I wanted to do a video about it so I could explain in a little more detail. And so here's the basic question I think that the real estate professional was trying to ask. She said, is the provision of a land title report to a buyer sufficient disclosure of an easement? So in this particular case, which we'll do another video on, and I'll link to it in the description. But in this particular case, the real estate agent had told the buyer not to worry about a survey, and I was making the argument, or trying to make the case that in this situation the buyer did need a survey, and that the easement was one of the reasons. And so I think this person asked a sincere question. She says, if the real estate agent or broker has given the buyer a title report, then they've done their, have they done their job? That's it, right? Like they should be done. It's up to the buyer at that point. So is that true under California law? Is that the case? And I would argue that the answer is no. So if you're a real estate agent or a broker in California, it's not enough to just hand your buyer a title report and then, excuse me, and then wash your hands and say, well, I've done my job. They've got the title report now. Okay, and so why is that? Why do I believe that fails to meet a real estate agent's obligations under the law? Why isn't that good enough? Okay, not just legally, but also ethically. Why is that not good enough? Now, I'm gonna make my case. I'm gonna give you 3 or 4 reasons why I think it's not sufficient to just give your buyer a title report. But I want to just go ahead and caveat that here. So I think what I'm about to argue applies in situations where the buyer is not sophisticated and the real estate agent or broker hasn't recommended the buyer work with a good surveyor. So if you have a situation where you have a sophisticated buyer, in other words, somebody that's done a lot of real estate transactions, they know the business, for example, a land developer, and the broker or agent has made a good faith effort to have the buyer work with a good boundary surveyor, if those 2 things are true, then providing a title report may be sufficient. Okay, but I would argue that in the majority of real estate transactions, neither one of those things is true. You probably don't have a sophisticated buyer. That's why they're working with the real estate agent to begin with. And secondly, most of the time the real estate agent isn't recommending that their clients talk to a good boundary surveyor. And I know this because I've been trying to work with real estate agents and brokers for several years, and I very rarely, if ever, have a real estate agent or broker follow through with a strong recommendation that their client talk to me. So if you've got a buyer that isn't sophisticated, in other words, they're not a land developer, they're not a professional real estate investor. So if you have an unsophisticated buyer and they're not working with a boundary surveyor already, why is it not enough to just hand that person, that buyer, that type of buyer, unsophisticated buyer, why is it not good enough to just hand them a title report? Why is that not sufficient to disclose the possibility of a problem easement? Okay, so I'm going to give you 3 reasons why I think under California law that's not good enough, and why ethically I don't think it's good enough for the agent or the broker. So here's the first reason. Land title companies miss easements all the time, frequently. I would say more than 50% of the land title reports we look at have some kind of problem or omission. I was just working on a survey this past week where the title company missed several easements that were shown on the tax assessor's map. Like, it doesn't get any more obvious than that, and the easements weren't in the title report. So that's the first reason. Title companies are not perfect. There are good companies, title companies, and there are bad title companies. There are good title officers and there are bad title officers. And title companies make mistakes. You can't just rely solely on the title report. And that's the first reason. Second reason is most buyers have no clue how to read and understand a title report. Most people in the real estate industry don't know how to read and understand a title report. You have some title officers and a few land attorneys that know how to read and understand title reports, and a few surveyors, a few types of surveyors. Even a lot of surveyors don't know how to read and understand a title report. So I don't think it's fair if I can't hand a title report to a majority of licensed surveyors and have them understand what's inside. I don't think it's fair to assume that I can hand it to an unsophisticated buyer of real estate and that they're going to understand it. And I think most judges, certainly in California, would agree with me on that. They're going to say, hey, real estate agent or broker, you're the professional. You were hired for your expertise. We can't expect, Grandma Sue over here to be able to read and understand this complicated real estate document. Okay, the third reason why I think it's not good enough to just hand your buyer a title report is seeing an easement on a title report isn't the same thing as understanding the actual impact of the easement. Okay, so when you see an easement listed in a title report, you don't have a full understanding of what the easement is, what it's used for, where it's located on the ground, and how it can be used by the easement holder, and how it's going to impact the use of the fee property owner, the person that's actually buying the underlying real estate. So in order to understand all that, you actually have to get the easement document, read it, and understand where it's at on the ground. Sometimes that takes a boundary survey. It doesn't always, but sometimes it does. So just seeing an easement listed in a title report doesn't tell you much other than there might be an easement. That's about all it tells you. So if you want to know more than that, you have to actually go get the easement document and you have to read it. And again, that's not something most unsophisticated buyers are going to do, or that it's not a document. An easement deed is not a document that most unsophisticated buyers are going to understand. In fact, I would argue that there are many real estate agents that aren't going to be able to read and understand an easement deed. So the bottom line is, real estate brokers and agents have a legal and ethical duty to help their buyers make good purchase decisions. That's why you hire an agent. And I'm not making that up. That is a legal responsibility. Real estate agents and brokers have a very high fiduciary duty to their clients, to their buyers. And they need to understand, what is the buyer trying to do? And is this property going to be a good purchase for them based on their goals and their needs as they've communicated to me? And so just to get back to this example, we're going to do another video about, but in this particular case, the real estate agent knew that the buyer was trying to build right after the purchase, and the easement was shown on a survey map, right? That's the type of easement that's most frequently missed by the title company, is easements that are dedicated on maps. And the agent knew that they had a small lot, compact lot, that the buyer was trying to build on, and in that situation, easements can have a huge impact on what you're actually able to build. So I think in this case, if the real estate agent had been doing their job, they would not have told their buyer after I had indicated they may want to get a survey that a survey wasn't needed. I think that was a bad call. So in summary, is provision of a title report sufficient disclosure to an unsophisticated buyer of the potential impact of an easement? No, I don't believe it is, not under California law. And I'd be willing to take the stand to testify to that fact. So it's something that I feel pretty strongly about. So anyways, I hope this video helps to answer those questions. It was a good question. I think it was a sincere question. And that's my answer. Real estate agents and brokers, you have a very important responsibility under the law and ethically to help your clients make a good purchase decision. That includes helping your client understand what easements might potentially burden a parcel and what the impact of those easements is. It's okay if you don't know how to answer that question as the broker or agent, but you certainly shouldn't be trying to talk your buyer out of getting help from a land surveyor that could answer those questions.